The freedom of expression in Brazil is protected by Section IV and IX of Article 5 of the Constitution of Brazil. Freedom of expression is not absolute. Article 5. Article 5 of the Constitution of Brazil encodes freedom of speech as a constitutional right. The article was approved along with the Constitution of Brazil in 1988. Article 5. All are equal before the law, without distinction whatsoever, guaranteeing Brazilians and foreigners residing in the country the inviolable right to life, liberty, equality, security and property. As follows. IV. The expression of thought is free, anonymity being forbidden. IX. Free the expression of intellectual, artistic, scientific and communication, regardless of censorship or license. Types of speech restrictions. There are several different types of laws that restrict speech. Moral harassment. When the individual has their dignity shaken through continuous and repetitive depreciation of their self-esteem, it qualifies as moral harassment, causing judicial proceeding and may be punishable by monetary compensation. Hate speech. Hate speech is not considered freedom of speech, causing arrest. Bullying. Bullying is not considered freedom of speech, causing judicial proceeding and may be punishable by monetary compensation. Crimes in the Penal Code. There are several articles of the Brazilian Penal Code that restrict freedom of speech, defining some speeches as a crime. Inducement, instigation or assistance to suicide. Article 122 causing or inciting a person to commit suicide or provide him assistance to do. Penalty, imprisonment from 2 to 6 years if the suicide is consummated, or imprisonment of 1 to 3 years if the suicide attempt resulting bodily injury of a serious nature. Single paragraph, the penalty is doubled. I. If the crime is committed by selfish motive. 2. If the victim is a minor or has diminished, for any reason, the capacity of resistance. Slander. Article 138 slander someone, charging him falsely, fact defined as a crime. Penalty, imprisonment from 6 months to 2 years and fine. Section 1. The same penalty whom know a falsehood, propagates or publishes. Section 2 is punishable slander against the dead. Section 3. It is recognized proof of the truth, unless I. If the offended has not been convicted by a final judgment. 2. The fact is attributed to any of the persons mentioned in item I of Article 141. 3. If the offended was acquitted by a final sentence. Defamation. Article 139 defame someone, charging him indeed offensive to its reputation. Penalty, imprisonment of 3 months to 1 year and a fine. Single paragraph, the exception to the truth only is allowed if the offended is a public official, and the offense is on the exercise of their functions. Injury. Article 140 insult someone, offending his dignity or decorum. Penalty, detention of 1 to 6 months, or a fine. Section 1. The court may disapply the pen. I. When the offended, the reprehensible manner, directly caused the injury. 2. For immediate retaliation, consisting of another injury. Section 2. If the injury is to violence or blows, which, by their nature or the means employed, if they consider demeaning. Penalty, imprisonment from 3 months to 1 year and a fine addition to the penalty corresponding to violence. Section 3. If the injury is to use elements of race, color, ethnicity, religion, origin or condition of elderly or disabled person. Penalty, imprisonment of 1 to 3 years and fine. Threat. Article 147 threatening someone, by word, writing, a gesture, or any other symbolic medium, of causing him harm unjust and severe. Penalty, detention of 1 to 6 months, or a fine. Outrage of worship, an impediment, a disruption of the act relating to it. Article 208. To mock someone publicly, by reason of belief or religious function. Impede or disturb ceremony or practice of religious worship. Publicly vilify material act or object of religious worship. Penalty, detention of 1 month to 1 year or a fine. Single paragraph. If there is use of violence, the penalty is increased by 1/3, without prejudice to the corresponding violence. Incitement to crime. Article 286. Inciting publicly the practice of crime. Penalty, detention of 3 to 6 months or a fine. Apology of crime or criminal. Article 287. Make publicly praise or justification of criminal act to crime author. Penalty, detention of 3 to 6 months or a fine. Contempt. Article 331. Insulting a public official on the job or by reason of their duties. Penalty, detention of 6 months to 2 years or a fine. Slanderous denunciation. Article 339. To cause police investigation, court proceedings, administrative investigation, civil investigation or action, administrative impropriety against someone, charging him crime that knows that he is innocent. Penalty, imprisonment of 2 to 8 years and a fine. Section 1. The penalty is increased by the 6th part, if the agent makes use of anonymous or assumed name. Section 2. The penalty is reduced by half if the charge is the practice of misdemeanor. False reporting of a crime or misdemeanor. Article 340. Provoke the action of authority, informing it of the occurrence of crime or misdemeanor that knows did not occur. Penalty, detention of 1 to 6 months or a fine. False self-accusation. Article 341. Self-accuse to the authorities of non-existent crime or practice by others. Penalty, detention of 3 months to 2 years or a fine. Increase of penalty for slander, defamation and injury. There are specific causes of increased punishment for slander, defamation, injury. Article 141. The penalties prescribed in this chapter is increased by 1/3 if any crime is committed: I. against the President or against the head of government. Foreign. 2. against a public official by reason of their duties. 3. in the presence of several people, or by facilitating the dissemination of slander, defamation or injury. IV. against a person over 60 years old or disabled, except in case of injury. Single paragraph. If crime is committed through payment or promise of reward, applies to pen double. Not punishable exceptions for injury or defamation. Article 142 do not constitute injury or defamation punishable. I. The offense made in court, during the discussion, by the defendant to his attorney. 2. The unfavorable opinion of literary, artistic or scientific criticism, unless there is the intention to insult or slander. 3. The unfavorable concept issued by a public official in the performance of duty. Single paragraph. In the case of sections I and 3, is punishable by slander or defamation who gives you advertising. Retraction for libel or defamation. Article 143. The accused before conviction apologize fully by the libel or defamation, is free from penalty. Single paragraph. Where the defendant has committed slander or defamation using media, the retraction will be given, if desired, by the same means in which it is practiced. Offense. Crimes in anti-racism law. Article 20. Practice, induce or incite discrimination or prejudice based on race, color, ethnicity, religion or national origin. Penalty, imprisonment for 1 to 3 years and fine. Section 1. Manufacturing, selling, distributing or using symbols, emblems, ornaments, badges or advertising using the swastika for the Nazi disclosure purposes. Penalty: imprisonment for 2 to 5 years and fine. Section 2. If any of the crimes provided for in the caput is committed through the media or publication of any kind. Penalty: imprisonment for 2 to 5 years and fine. Crimes in the Anti-Discrimination Law 2 HIV positive. Article 1. It is a crime punishable by imprisonment of 1 to 4 years and a fine. The following discriminatory behavior against HIV positive and AIDS patients because of their carrier status or ill. To disclose HIV positive status in order to offend his dignity. Constituição de Brazil. Brazil Constitution. In Portuguese. Retrieved 21 December 2013. Código Penal Brasileiro. Brazilian Penal Code. In Portuguese. Retrieved 21 December 2013. Lei Anti-Racism. Anti-Racism Law. In Portuguese. Retrieved 4 July 2016. Lei Anti-Discriminação ao Portador de HIV. Anti-Discrimination Law 2 HIV positive. In Portuguese. Retrieved 4 July 2016.